Good morning, Mr. Posenberg. I haven't seen you in a while. I knew I'd see you in this case at some point.
Order 16 is now in session on.
Thank you, ma'am.
Please be seated. Thank you.
All right, I want to say good morning, everyone, and welcome you to the Friday, February 9th, 2024 special session at 10 o'clock a.m. Let's go ahead and set forth our appearances for the record. We'll start first with the plaintiff, then we'll move to the defense.
Your Honor, Will Kemp and Peppermint for plaintiffs.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Abe Smith for Milwaukee.
Good morning, sir. All right.
Good morning, Your Honor. Joe Reynolds and Chad Fears on behalf of Milwaukee Instruments.
And good morning to you fine gentlemen, too. And we can go ahead to Zoom or Blue Jeans. I don't know which one we're using. But let's go ahead and set forth our appearances.
Good morning, Your Honor. This is Teddy Parker on behalf of the plaintiffs as well.
Good morning.
Good morning, Your Honor. Joe Ledoux on behalf of the Real Water defendants on Blue Jeans still.
All right. Good morning, sir.
And Your Honor,
Good
Jim
morning, Your
Neale.
Honor. Dan Polsenberg, also for Milwaukee.
Good morning, Mr. Posenberg. I haven't seen you in a while. I knew I'd see you in this case at some point.
Your Honor, Jim Neale for UNFW, just observing today, but good morning.
Good morning, Mr. Neal. I hope things are going well for you, sir.
Thank you, they are.
All right. Okay, let's go ahead and get to the issue at hand. And let me see what we have. We have a Milwaukee Instruments motion for an order confirming automatic stay of execution on an order shortening time. Sir, you have the floor.
Good morning, Your Honor. Would you prefer me to be here? Or
Sir, I prefer whatever's comfortable for you.
I'll just stay here in that case. And I do apologize. I've had an ear infection, so I'm slightly deaf in one ear. If I have to ask you to repeat things, that would be why.
And that's fine, sir. And I do feel for you because that's something I don't want anybody to have. But go ahead, sir. Tell me why this judgment is not final. I mean, at the end of the day, we're talking about finality, right?
Correct, Your Honor.
And what's pending as far as the third-party actions in Department 16?
Correct. So I think we've got at least two issues. One is, I think the easiest one is the UNFI versus Real Water claim. Plaintiffs say that there was some announcement in bankruptcy court that the parties had reached a settlement or settlement in principle. But there's been no action in this case. That claim is still outstanding. In fact, the Nalder case
was that claim removed to bankruptcy court?
No, it was not.
Okay.
So the removal was by the insurance parties,
and it's in federal court.
In federal court, correct.
Okay. And the reason why I'm circling back, my question is, what's pending currently in Department 16 for the 8th Judicial District Court for the state of Nevada, as far as claims are concerned?
Yes, Your Honor. And just to address the removal real quick, so this was not a 1446 removal where it's, the state court is disabled entirely because the entire case.
No, I understand.
Okay.
But at the end of the day, I just want to know what's remaining to be adjudicated in this department.
Right. So as I understand it, you've got the UNFI versus Real Water third-party claim because that has not resulted in a final judgment. There's been some announcement of a settlement, but that settlement has not been memorialized in a written judgment that would have to be entered in this court.
Or you mean a settlement agreement?
Well,
and dismissal.
There would have to be a dismissal, exactly. I mean,
not a judgment, but there can be a dismissal. But go ahead.
Well, I mean, the dismissal would act as a final judgment if there is in fact a dismissal. But the mere fact of a settlement is on its own not enough to constitute a final judgment. That was made clear in the Nalder case, where the plaintiffs there, the plaintiff and the first party defendant tried to enter into a settlement agreement. They even sent it to the court. There was also an insurance party, an intervener in that case, and the court said, "Well, I'm not signing off on your settlement agreement." And the Supreme Court said, "Yeah, just because the judgment, there has to be an actual final judgment entered as to that claim." So that one is for sure pending. And then with respect to the Real Water Tennessee, the UNFI's claim against Real Water Tennessee, this court's order granting summary judgment expressly retained jurisdiction depending on what the bankruptcy court does with the effective date of the consolidation. And it says, I'm quoting from the order now, this court will retain jurisdiction for the purpose of further adjudicating third-party defendant Real Water Tennessee's motion for summary judgment relating only to plaintiff Keith Haley's claims against UNFW. And then the last piece is, of course, the plaintiff's claims against the insurers. Now, it's true that because those claims were removed to federal court, there is a stay in this court. Automatically, the parties would not be able to proceed on those claims in this court, but there's not a judgment as to those claims. Just removing the claims to federal court doesn't affect a dismissal or other judgment. And because we're talking about,
But I mean, if it's removed to federal court and assuming it's not remanded back, I will never be in a position as a trial judge to adjudicate the claims potentially as a matter of law, or a jury won't be here to determine the facts and adjudicate the finality of the claims, right?
that's correct, Your Honor. Yeah, but I think what we're talking about is the issue of finality for purposes of appeal, right? So it wouldn't matter which court enters the judgment. There's not an adjudication as to those claims.
So you're saying that hypothetically you could have a scenario where you have direct claims against a manufacturer, and then there's third-party claims out there potentially regarding contribution and or indemnity, and until those claims are perfected and ultimately adjudicated on contribution, hypothetically, there would not be finality if a judgment was entered in this case?
Correct. Not unless there were, 54B certification or some other mechanism of creating.
Even though they're no longer part of this case.
What maybe I misunderstood the hypothetical.
Well, the question, for example, what's the statute of limitations for a contribution claim?
A year after.
Okay,
It's a
right.
year after.
Right, so you don't even have to file those claims until after,
Correct.
1 year after judgment. So if I follow your line of logic, what you're saying, Judge, you don't have finality until those contribution claims are resolved.
Oh, I'm sorry. So I did misunderstand the hypothetical. I thought you were talking about contribution claims that were raised in the underlying action. So if you're talking about an underlying claim that's been adjudicated and results in a final judgment, and then a year later, the parties file a contribution claim that results in a new action, no, those would be two separate actions. And it does make a difference, right? Because if the third party claims had been brought in a separate action, I would agree that there would be Rule 54 finality for purposes of Rule 62 execution, right? Because then you would have two separate cases, and each case could reach finality within itself. But no, you can't have finality of the judgment in a single case where there are multiple claims pending, right?
But multiple claims pending in this court. That's my question. I'm really focusing on what's in front of this district court, meaning here. And you say there's one contribution and or indemnity claim that hasn't been resolved. But then you're talking about other claims. If claims are in bankruptcy court or claims are in the federal court, why won't that impact finality as far as this court is concerned? That's my question, because I do understand that the third party claims or potentially some have been removed to federal court for whatever reason, and that doesn't concern me. I'm just focusing on the finality issue in front of me.
Correct, Your Honor, and I appreciate you asking the question because
that's the question, right?
Yeah, I think what you're getting at is, well, even if everybody agrees that there's not finality today because of the absence of a judgment as to the UNFI versus Real Water claim.
In this department, I'm focusing on litigation.
Yeah, well, that one is in this department. That one
Okay.
hasn't been removed.
Right.
But even as to the insurer, the third-party claims against the insurance companies, which have been removed, I think it is important to establish, okay, what will be the date that establishes finality as to all the claims? It would be the date that those claims are adjudicated in some form, whether it's because the claims are remanded.
Who says that? Where does that come from?
So, for example, we cited the Turner case from Missouri. This issue's not come up because, frankly, Rule 9027, Bankruptcy Rule 9027 removal is not as common, right? So it's a little bit unusual to have some claims pending in state court and others removed, where you could potentially have a judgment in both state court and federal court, right? Obviously, if it's 1446 removal, then the judgment is just going to be in federal court, and the appeal is going to just be in federal court. So the question of finality is a little bit moot. But actually, to that point, let's talk about the simpler case, Your Honor, right? So if you have a case that's filed in state court, a plaintiff versus a diverse defendant, right? And then the claim is.
What do you mean by diverse defendant? I don't understand that, because this is state court, assuming I have personal and general jurisdiction.
Yes, right. So let's assume.
I'm trying to figure that out, right?
Okay, sorry. I apologize. I'm making up a hypothetical.
Because you're talking about diverse, that triggers some sort of federal court analysis and diversity jurisdiction.
Well, that's where I'm getting, right? So if the claim is initially filed in state court, but because there's diversity and the amount of controversy exceeds $75,000, the claim is removed to federal court.
It's no longer in my court.
Then it's no longer in your court. But is there a final judgment? Absolutely not.
But I don't understand that, because the final judgment would be in federal district court, and then ultimately
Exactly.
the issue would be whether or not it meets the requirement of USC Section 1291 from a federal law perspective.
Correct.
Right, and so
Right.
it would be out of my hands. But that actually underscores my question as far as finality in this court. Right, that's what I'm focusing on: finality in this court. What's left to be adjudicated before me?
Well, I mean, again, the UNFI versus Real Water claim absolutely has to be adjudicated in front of you, and the Real Water Tennessee claim where the summary judgment order says that you're retaining jurisdiction, those absolutely have to be adjudicated in front of you. All I'm addressing, I mean, so either one of those would be enough to say, yes, there's not a final judgment, we need to stay. But I understand you still want to button up this last issue about the.
I mean, I
insurance
think
claims.
at the end of the day, that's what I really have to focus on, right? Because that triggers the appellate issue, finality.
Well, I agree with you, Your Honor. Although you just, even if you were to conclude, which I think would be wrong, even if you were to conclude that removal somehow effectuates finality as to the insurance party claims, that of course would not be enough to establish finality as to all the claims, because those aren't all the claims.
Well, here's my question, because let's not parse it. I mean, once a case or claims are removed to federal court from a district court, what rules, laws, or statute that are out there that impacts what's left here, right? If that's removed, it's gone. And if there's a decision made on the state level, you have appellate rights, and potentially, if that's a final decision, notwithstanding what's been removed, it seems to me there might not be what's called, I guess you're calling it, federal tolling of finality, because there's a removal of a third-party claim to federal court. That's what you're saying. So, Judge, it's tolling the rule. Whereas there's nothing left for me to adjudicate.
Well, I mean, as far as you know, yeah, right? That's why it's called a stay, right?
But there's no
removal
stay.
effectuates a stay.
There's no stay impacting me as far as this case is concerned, is there?
Well, yes, as to the third-party claims against the insurers. Because
Well, no, those have been removed.
those have been removed, exactly.
But so there's no stay. There's not part of my jurisdiction. They're in federal court.
Not currently, right?
Yeah.
But-
That's
but
different
what-
than a stay, right? Bankruptcy stay, execution, and all those things. I understand stay.
Well, but what happens in an ordinary removal, right? You remove.
I'm done. That's what happens.
Unless-
And then it gets remanded, then I deal with it. But once it's removed, it's not in my jurisdiction, right?
For the time being, correct? Yeah.
Yeah, but I mean, I don't look at it. I mean, once it's gone, it's gone.
No, it's not.
Well,
That's why-
I'll
that's
tell
why
you.
have
Well,
to
that's
go
what
to
you
the
say.
case.
But I'll tell you, as a trial judge for 18 years, if a case is removed to federal court, it's outside of my jurisdiction,
Correct.
and they deal with it.
Unless it's remanded.
Right. But
But you're
I'm not
asking a question
qualifying.
about appellate finality.
No, I'm talking about jurisdiction and finality. That's what I'm talking about.
Jurisdiction and finality are two different things, though.
Yeah, I agree. But
Yeah.
you don't see it my way, and that's a problem for you. I don't mind saying it, because I'm asking questions regarding finality. I
Right.
accepted two of your responses. You said, well, Judge, we have two things that are currently pending in district court, right? I'll be candid with you. I'm not concerned about what's going on in federal court.
Okay.
I'm not. I've had too many cases removed. Some of them come back, some haven't. But that's up to whatever fine federal judge is handling that matter to adjudicate that and bring it to finality of some sort.
So do I understand you correctly that you agree that the two claims that are pending in state court and that have not been removed, that those do defeat finality, but that if those claims are resolved?
Well, my question is this. I didn't agree or disagree. I asked you to identify for me what was currently pending in front of me. And you said there's two claims, and that's your response. I haven't agreed on anything.
Okay. Well, that is
Right?
my response, right?
Right? I haven't. I just want to know, what are the facts? That's all.
Yeah, and I agree with you, Your Honor. There are two claims currently pending.
Well, there's nothing to agree to. I just asked a question. What's pending? I haven't agreed to anything. Yeah, I mean, I just want to know what's pending so I can make a decision. That's
Real
all.
Water, UNFI versus Real Water, that's pending.
Right, okay.
And UNFI versus Real Water, Tennessee, that is pending because of the caveat that's carved out in the summary judgment order.
And so the first one is pending is UFI versus
Real Water.
Real Water. And the second is currently
UNFI
pending.
versus Real Water, Tennessee.
Okay, what's going on in those cases? Okay, the first one, I guess, is UNFI versus Real Water. What's going on there?
Correct.
What claim is that for? I kind of anticipated what it would be for, but I want you to tell me.
I apologize. I don't have the third-party complaint in front of me. I believe it's for indemnity or contribution, but I wouldn't be able to say which. Perhaps Real Water's counsel can clarify that.
Okay. And thank you on that. What about the UFI versus Real Water? What's going on there?
I believe that's the same. That would also be a third-party contribution or indemnity action.
Okay. Let me see here. Okay, thank you. Keep that up. All right, go ahead, sir.
Well, unless you have any other question, I mean, I hear we're a little bit of an impasse on the issue of the federal court removal and whether that affects a stay or an actual adjudication of the claims for purposes.
That's okay.
But I don't.
That's okay.
The other thing I just point out, Your Honor, is that I'm not entirely sure that the plaintiffs have reached an agreement with other defendants to not execute, but they're not willing to extend that to our defendant.
Why does that matter?
Well, Your Honor, I mean, I think.
I mean, I can think of a lot of reasons why they wouldn't. You know, I mean, for example, some of the parties admitted to liability, right? And there was a lot of concessions made. They're probably working together behind the scenes. And you have to remember this. This is an adversarial process. Your client didn't admit to liability. That's my recollection, and so on. And so they can have. There's nothing wrong with them agreeing to prosecute their cases in a certain manner with those that have reached tentative settlements regarding liability and all those things. You know, that's just kind of how it is.
Yeah, but you still have to follow the rules.
But what rules have they not followed?
62A gives us an automatic stay for 30 days following notice.
But that's not a question of following the rules. I thought when you said they have to follow the rules that there was something unsavory about that.
Your Honor, I do think it's unsavory when they're threatening execution against my client and they don't have a final judgment.
Well, I mean, that's different than unsavory. I mean, you might feel that's procedurally inappropriate. That's a different issue, right?
Well, and I asked them to explain to me why it was that they thought there was a final judgment. Back in November, they refused to explain to me why they thought there was a final judgment. And in the opposition, all I get is stuff that happened after I had that conversation, which to me indicates they didn't even have a colorable basis for thinking that they had a final judgment at the time.
Well, I mean, all I can say is this. That's part of, I guess, high-stakes litigation, right? That's what it is. I mean, what was the verdict in this? 224 or something like that?
The total verdict, yeah, something like that, against our client, I believe it was 38.
I mean, that's high stakes.
Right, which is why I think it's especially important for parties to follow the rules and not threaten unlawful execution. Thank you, Your Honor.
All right, thank you, sir. Mr. Kemp.
Threatened with a Rule 11 violation either, Your Honor. But anyway, so you got to take a look at what's really going on here. What is going on is they don't want to post the bond.
No,
So,
I understand
they're
that.
playing a finale game, is what I call it. But let's take the original motion and let's take the new argument that they flipped it to. In the original motion, they say, quote, "It is undisputed that third-party claims and cross-claims remain unresolved," unquote. That's on page 6, lines 2 through 3. So they just came in here, filed a motion, and said, "Judge, there's nothing left in front of you." Okay, in the opposition, we point out, one, the Real Water Tennessee claim was dismissed. Mr. Kavanaugh came in and argued the motion for summary judgment. The court
Well, I
granted-
remember that.
Yeah.
I mean, I do remember that.
Yeah, and so now they go back and say somehow there's some residual jurisdiction there. Not only has that claim been dismissed, but there's been notice of entry of order filed on that long ago. So they're saying that that claim remains to be tried in front of the court. That's just not accurate, Your Honor. The second claim that they argue is this, and remember, this is a new argument made in the reply. In the motion, they said it was undisputed. So now they argue, oh, UNFI and Liberty have reached a settlement of their other claim, and they didn't point that out in their motion, Your Honor. When we pointed it out, only then did they acknowledge it, and we cited the transcript from the bankruptcy court where two times, UNFI said on the record and Liberty acknowledged that they had reached a settlement. Okay, that happened about 30 days ago. You know, UNFI and Liberty are two of the biggest companies in America. Now counsel comes in and he says, oh, well, that's just a settlement in principle, implying that there's no
Well, it's
settlement.
on the record in bankruptcy.
It's on record in bankruptcy court. And is there a settlement agreement? We don't know because counsel, who's being paid by Liberty, hasn't supported anything with an affidavit. You know, he says in the reply, oh, it's just an agreement in principle. Where's the affidavit? Why didn't he call up Liberty, who's paying him, and say, well, what's the status of this? So it's either a settlement agreement or they're still goofing around with it. And what they're really doing, Your Honor, is they're taking this settlement and they're trying to create it as a mechanism to avoid posting the bond. You heard counsel, until we decide to execute a settlement agreement, until we come to this court and get that claim formally dismissed, only at that point in time do we have to post the bond. So we control the court's
Well, I mean, and correct me if I'm wrong, Mr. Kemp, you can effectuate settlements many different ways, but one of the enforceable ways is to place it on the record in a court of law.
Exactly, Your Honor. And no one's saying that settlement has fallen apart, okay?
It might be tough to fall apart if it was put on the record.
Right. So
I'll say
this
that.
is the claim that they're telling you needs to be tried in this court, the settlement claim. Okay, now we get to the third one.
And I want to make sure I understand because, and for me, many times what happens in cases like this, I can get a handle on the law. I just want to make sure I understand what the facts are. And that's why I always get back factually heavy. So would that come under one you're talking about right now? I'm looking here. He cited two claims. He cited UNFI versus Real Water.
Right.
Then there was UFI versus.
There's the Tennessee claim, Real Water Tennessee, as opposed to the Real Water. So the Real Water Tennessee we've already talked about.
Okay, that's the one that was for someone on the record.
That's the one you did the summary judgment on.
Okay.
The Real Water, the other Real Water one, that's the one that settled, that they put on the record. So how they can come in and say with a straight face that there's going to be some kind of trial in this court on either one of those claims, it's really preposterous. Okay, now let's go to the third one, because the third one I really love. So the third one, this is the 7 Gallagher plaintiffs sued Liberty for their intentional interference contract. If you recall, Your Honor, well, maybe you don't recall, but we got approval from the bankruptcy court to come over here. We cut a deal with the trustee. The agreement was we could pursue the state court litigation.
I kind of remember
Then we
over
get-
that.
Yeah, we get 5 weeks away from the Gallagher trial starting, and Liberty decides, oh my God, we're going to be hit big time. So they go back to the bankruptcy trustee, written agreement to give him $400,000 if and only if he will go in and repudiate his agreement, which he tries to do in bankruptcy court. So we sued them for intentional interference of contract, i.e. the agreement we had to pursue this litigation. I mean, it was so bad that they had a written agreement with the trustee that he had to file a federal action, which he did, against the 7 Gallagher plaintiffs and try to get a restraining order, which the federal court wouldn't give him. They tried to stop the Gallagher trial. So that's the intentional interference of contract that's in the third-party complaint. But they removed that complaint. They removed that portion of the third-party complaint to federal court. And I emphasize they removed just that portion. They didn't remove this entire Gallagher case. And that's important when we look at the Turner case, which they cite as authority for this dual jurisdiction proposition. So what they are arguing, I call it dual jurisdiction. quantum theory, that two things can be in the same place at the same time. That's quantum mechanics.
Right.
So their argument is that even though they removed it to federal court, that it's still over here, that there's dual jurisdiction. That's the argument counsel's making. And he cites this Turner case, which is a case from the appellate court in Missouri. Okay, but Turner actually directly supports our position. In Turner, they removed the entire case. They didn't remove just part of it. But the Turner court says, quote, after removal, the state court loses jurisdiction until the federal court restores it. Exactly what Your Honor just said.
That's fundamental there.
Right.
I mean, that's like fundamental.
Two, state court jurisdiction is only restored once a remand order is certified and mailed to the state court. That hasn't happened.
Once again, that's
pretty fundamental, Your Honor. Okay? And then this case, like I said, in Turner, the entire claim was removed. So Turner didn't have this partial removal that we have here. But that's all gone, Your Honor. So they can't, and who removed that? Liberty removed it, all right? So the consequence of Liberty removing that is that made this into a final judgment, which causes extreme peril to Milwaukee. So Liberty has really committed yet another bad faith act. And so now Liberty's coming in and they're saying, oh, this isn't final because we don't want to post the bond. So they put their insured in harm's way by making this a final judgment. And then they come in and they want a stay for, I don't know how long they want this stay for, but they're not entitled to any stay, Your Honor. And I go back to the original point that they made, quote, it is undisputed that third-party claims and cross-claims remain unresolved. That's just not true. The first one, summary judgment. The second one settled, and the third one removed. So for that reason, the motion should be denied, Your Honor.
all right.
Your Honor, it is true. I'm quoting now from Gallagher versus 8th Judicial District Court. We did not, nor do we intend today, to state that a settlement agreement on its own stands in the place of a judgment. I don't know what more to say. They've quoted, they haven't actually attached the bankruptcy court transcript, but be that as it may, they quote from a hearing in bankruptcy court.
So let's go a little bit deeper than that as far as the settled case is concerned, because it's my understanding the settled case was removed to bankruptcy court, correct?
No.
Okay. When was the settlement entered into?
I have no idea, Your Honor. I don't even know if there's actually a settlement agreement. The only thing they cite to is a transcript from bankruptcy court talking about a settlement in principle.
And the settlement in principle would be between whom?
Between UNFI and Real Water.
Okay. And you're representing in this case?
I'm sorry?
You're representing in this case? I just want to make sure I understand you. Who you?
Oh, who I'm representing? Milwaukee.
Okay. So UNFI and Real Water. All right.
Your Honor, when the time, this is Jim Neale for UNFI, and I don't mean to interrupt, but when the time is right, I'd like to be heard on that, if I may.
Mr. Neale, I've always given you a chance to express what you want to place on the record, sir. But remind me, because just in case, because I don't want to overlook you. But remind me, and I'll give you a chance to do that and address that specific issue.
Thank you, Your Honor.
All right, but go ahead, sir.
Yeah. So, and I don't think if I said that there was going to be a trial, I may have misspoke. I never intended to say there was going to be a trial, but the Supreme Court is clear that just having a settlement agreement, an adjudication of the claim. It's not a final judgment. There needs to be a written final judgment of the claim. And
Well,
the claim is not removed
when you settle, you don't give a final judgment. You typically have a stipulation for
to dismiss. And I apologize. I'm using the word judgment in the appellate sense. So yes, it would be appealable once you have the order of dismissal entered. And that claim, because it's not been removed to bankruptcy court, that claim is in front of you. You don't have an order in front of you dismissing that claim. That claim is still pending in this case. I would be surprised if there's a trial of that claim, but the reality is until there's an order, a written order dismissing that claim pursuant to the settlement agreement, if there is in fact a settlement agreement, then and only then would that claim be adjudicated. I mean, Your Honor, the Nevada, you've read the opinions, right? The Nevada Supreme Court's very cautious about its appellate jurisdiction, and it's very cautious about setting traps for the unwary. That's the.
I'm very cautious about my jurisdiction and making sure I don't step on the toes of a federal bankruptcy judge and/or a federal district court judge.
Right.
And that's like, once again, once a case is removed, I'm done. I don't mind saying that. I don't monitor the case. I don't look at it from a dual jurisdictional case. There's no decision I can make if that case is removed to federal district court as far as the merits are concerned.
I agree, Your Honor. I've never said that there's dual jurisdiction or quantum jurisdiction or anything else.
His statement that there's dual jurisdiction appears, I believe, on page 5 of his reply.
Well, okay, so I apologize. With respect to the non-removed claims, there's jurisdiction in this court as to the non-removed claims. And with respect to the removed claims, there is potentially jurisdiction in bankruptcy court unless the bankruptcy court remands. But the whole point is that the removal of those claims affects a stay. It does not affect a dismissal, an adjudication, anything else that creates finality for purposes of appeal to the state Supreme Court.
Well, here's at the very outset, that's one of the reasons why I focused on, and it was a real simple question, what is left to be adjudicated in this department, in this court before the 8th Judicial District Court for the state of Nevada? Real simple question. I know there's one claim where I granted summary judgment. Is that left to be adjudicated by me?
Yes, Your Honor, because you've got the caveat in the order. Apologize, let me pull it up real quick.
What order? Tell me what order. What
this is your findings of fact, conclusions of law, and order granting third-party Real Water of Tennessee's motion for summary judgment from December 1st of last year. In the very last paragraph, should the bankruptcy court determine that the effective date of the substantive consolidation is earlier than the petition date, August 19th, 2021, this court will retain jurisdiction for the purpose of further adjudicating third-party defendant Real Water Tennessee's motion for summary judgment relating only to.
Has that happened?
Not yet, but Your Honor, this is the whole point. For an appeal, I can't go up to the Supreme Court and say, well, for now you have appellate jurisdiction, but if some trigger event happens in the future, then you'll lose your appellate jurisdiction because there will then be an unresolved claim in the district court. Appellate jurisdiction doesn't work like that.
What would be the unresolved claim if I granted summary judgment?
Because you reserve jurisdiction.
But what would be the unresolved claim if I granted partial summary judgment?
Exactly what you said in your order, that you're retaining jurisdiction.
No. There's a difference between jurisdiction, right? Mm-hmm. It can be in rem, it can be in personam, right? We understand that, and so on. But I mean, or it can be, we'll get a little bit more specific, I guess. But anyway, why would claim, because at the end of the day, what I'm really focusing on is finality. That's what the law mandates, right?
Right.
Finality.
As to all the claims, yes, you are correct, Your Honor.
But I granted summary judgment, so that claim's been resolved from my perspective. But go ahead.
All right. So, and then the last, I feel like we're going around in circles here.
No. I'm trying to make sure I understand what, and you're saying, look, I guess there's two. Summary judgment has been granted on one claim, right? Then there's the removal claims that are in federal court. We've discussed those. I guess last is the settled claims is it Real Water of Tennessee?
Was just Real Water.
Okay, but the settled claims, Mr. Neale, I know he'll talk about that. He'll give me an update on that.
And that and like I said, there's clear Nevada Supreme Court precedent that the settlement is not in itself effective to create finality for appeal. That there would need to be an order entered in this case, dismissing the claims or whatever the resolution is, to create an appealable order. And while until that's submitted to you and signed by you and entered as a judgment or dismissal, those claims remain pending. So I guess let me pivot, Your Honor, because if you really are considering not granting this motion, I would ask that you at least entertain a temporary stay so that we can go up to the Supreme Court and get this.
Well, we
issue
have to do that
adjudicated.
procedurally, right? We have to, I mean, I think one thing I'm known for over the last 18 years would be this. I look at parties, I give lawyers a lot of discretion. I really and truly do. But if they don't agree, we have to follow the procedures.
Right, so I would be making,
Well, yeah, I
in that
understand.
event, it'd be an oral motion for stay and they can respond.
Yeah, no, we don't do it that way. I sign order shortening times, but I always try to make sure I give the other side enough time to respond. Typically 10 days, maybe. I know the rule I think says 14, but I always try to make sure that adequate time is given to file an opposition, because I've been in that position as an associate and I have to get stuff done in like 24 hours, and that's not fair. But go ahead.
Well, Your Honor, I guess what's a little bit, I don't want to say frustrating, but I've not heard anything from plaintiffs disputing the authority of the Nalder case that says that a settlement agreement on its own is not enough. And so I guess what I'm concerned is if they're going to be asking this court to disregard that and say that that's nonetheless a final judgment, then I do need some kind of temporary relief, because they're threatening.
No, I understand that. I do.
Okay.
I'm going to hear from Mr. Neale and so on as far as the settlement's concerned.
Very good, Your Honor.
All right. Mr. Neale.
Thank you, Your Honor. And I have to apologize. I didn't expect to participate today, so I'm not
That's
entirely
okay.
properly attired. And my local counsel's not here. I trust nobody will object if I proceed solo. I don't want to take a position on the motion, Your Honor, but I do want to make sure that none of our cross claims or third party claims are adversely affected by anything that happens here today. So here's the status of UNFI's claims, Your Honor. We have a cross claim for contribution and indemnity against the real water entity. Number two, we have a third party claim for contribution and indemnity against Real Water of Tennessee. This court granted summary judgment on that. That was dismissed as to one plaintiff with prejudice and as to one plaintiff without prejudice. Finally, Your Honor, and I don't believe I've heard mention of this at all, but UNFI has third party claim against Real Water Gold Coast, LLC, a portion of which has been assigned to the plaintiffs as part of the resolution of Mr. Belsky's case against UNFI. So there are three claims: cross claim against Real Water, third party claim against Real Water of Tennessee, and the third party claim against Real Water of Gold Coast. The first claim, Your Honor, that cross claim against Real Water of Tennessee, is not settled. Mr. Kemp is correct that there is a settlement agreement with Liberty Mutual, which is one of Real Water's insurance companies. That insurance company is essentially buying out its contract in the bankruptcy court, or attempting to. But there are other insurers of Real Water with whom UNFI has yet to compromise its claim. So again, I'm not taking a position on the pending motion, but it's important that the court not dismiss or otherwise compromise the pending cross claim against Real Water and the pending third party claim, portion of which plaintiffs share, against Real Water Gold Coast. So factually, Your Honor, that's the procedural posture in which UNFI currently sits. The court may recall saying there would be a phase 3 where those cross claims and third party claims would be adjudicated, and I'm happy to schedule that or speak to that or take the court's direction regarding that.
Well, as far as that's concerned, there's no question, Mr. Neale, I did say that. And historically, that's how we've proceeded in many cases, and I think they pointed that out. I'm looking at it from this perspective, sir. your discussion, that's probably the best way to say it, was used for the purposes of educating me as to the current status of those claims.
Thank
Nothing
you.
more, nothing less.
That's the intent.
Right, Mr. Kemp, you want to add into that?
Yeah, Judge, I don't really understand what Mr. Neal's position is, because he says there's a settlement contract, which we haven't seen because on the bankruptcy court they said it was confidential. But he appears to be saying that it settles some of the claims against Liberty, but not all the claims against Liberty, and that there's other insurers out there. Well, we've been chasing insurance for quite some time, specifically on Real Water Gold Coast. So if he's saying there's some other insurance out there, that would be one thing. But I have a hard time believing that Liberty entered into a settlement agreement with him and they settled part but not all of their liability in this case. So if that's the representation he wants to make on the record, great. But I think we need to see that settlement agreement, because and if Liberty is trying to manipulate the situation here by settling some or all of its claims to avoid posting a bond, that's another fact that I think we need to analyze. But so I would just ask that if there is a settlement agreement, it should be lodged with the court, Your Honor. If there's a settlement agreement that allows some of these claims to go forward and not others, that's a brand new fact that's not set forth in the motion. That counsel in the reply said that settlement was in principle only. Now we find out that there's a settlement agreement. I don't know how you can grant a motion based upon a representation that there's a settlement agreement that carves out some but not all the claims without seeing the settlement agreement.
Well, I have kind of like a different viewpoint. Mine's from a judicial perspective, and it's more concerned with my docket and the current case status. Because hypothetically, if there's a settlement and it's been perfected, I think it should be reflected, not necessarily the amount of the settlement if it's confidential or something like that, but what impact it has on the case pending in front of me procedurally. Right? Because, and here's my point, if there's been a settlement between the parties, I need to know that, because that's something that shouldn't be adjudicated because there's a settlement, right? And we don't want to, I guess the bottom line is, I think from a procedural perspective, that's one of those things you need to know as far as the case is concerned. Because if that claim is resolved, it should be removed from the action, right?
And of course we would do that, Your Honor. There is no...
Oh, no, Mr. Neale, I'm not saying you did anything wrong. Trust me, sir. I really respect you. I understand you didn't win on everything, but you did a fine job. You gave me pause.
I will just reiterate for Mr. Kemp's sake that none of the claims that UNFI brought in the Gallagher case have been settled in the bankruptcy. Not one.
All right. Okay. Anyone else want to place other issues on the record? Because this is the way I'm looking at this. I do have a much better understanding today, but ultimately I want to make sure whatever decision I make withstands review. I mean, that's always what I'm thinking about. It's not what I want to do; it's what I think would be appropriate. And so, as far as, let me look here. I need some clarification for now, because I'm looking at it through this lens, and I think I started out the entire discussion at the very beginning focusing on finality, right? When I first hit the bench, that's what I wanted to talk about, finality. And it seems to me we have the summary judgment. I mean, summary judgment, right? I granted that, so we have finality there. I'm not accepting the dual jurisdictional issue, right? I'm not. Once a case is removed to federal court, it's off my docket. And to be candid with everyone, I don't follow it anymore unless it gets remanded again back to me. And many times if it's removed, I said, okay, that's off my plate. I don't have to deal with it, you know. But the only question I have is the status, Mr. Kemp, of the settled claims. Specifically, what's going on there. I think you have a question too regarding that issue. I don't know where we go.
They told the bankruptcy court it was settled, and now we're hearing there's a settlement agreement that they're saying maybe some settled, not others settled. So.
Well, here I'm looking at it from this perspective because I think this is important. It really is. If a claim is settled, then it should be dismissed from the docket, right? Shouldn't this be sitting there?
That needs to happen, correct, Your Honor?
I mean, that's, procedurally what happens. And I've even what I do from just a general case management issue. That's why I have status checks and things like that post just to make sure those documents come down. So anyway, this is what I want to do. I need going back to the call of the question. All right, I'm looking here, and this is probably the best way I can do it at page 8 of the moving motion. And it says, accordingly, Milwaukee asks this court to enter an order clarifying that there is no final judgment for plaintiffs to execute upon. And at this time, I look at this, that's a very general question. We have summary judgment, that'd be finality. We have to remove the federal court, that would be finality. As far as specifically relating to, is it UNFI? Did I get that right?
I think that's the abbreviation we've been using sometimes.
Right. I need clarification because this is what I'm going to order, that if there has been a settlement agreement in this case as it relates to UNFI, I'm going to require some action as it relates to the procedural posture of that case in district court, because if it's settled, there should be dismissals.
In Your Honor, we did just hear from Mr. Neale that there's the separate third-party claim by UNFI against Real Water Gold Coast that is not settled.
Judge, that's also insured by Liberty. I can't imagine for the life of me that Liberty would settle part of the claim against it, but not all of it. But we can see the settlement agreement.
This is what I'm going to do. I'll make it real simple. I'm going to need that. I'm going to set this for a status check on that specific issue in 2 weeks. How's that? That should be enough time.
And does Mr. Neale need to provide the settlement agreement to us?
Mr. Neale, what about the settlement? I don't know about. This is what I'm really concerned about. Where this case is procedurally as a result of the settlement agreement. How does that impact?
I understand, Your Honor. There is no signed agreement. There is one being negotiated. When it is executed, it will not dispose of these claims. We'll be happy to provide it to the court in camera or a redacted copy to the parties that excises only the settlement amount. But the claims, I will repeat unequivocally, the cross claims against Real Water and the third-party claim against Real Water Gold Coast are not dismissed as a result of the agreed-to settlement.
Right. All right.
Well, Your Honor, can I have a date that he's got to give us the settlement agreement before the status check?
Clarify that again, Mr. Kemp, for the record.
Can I have a date by which, sometime prior to the status check, the settlement agreement redacted is fine.
Yeah.
But
3 days before?
3 days is fine.
That's fine, Your Honor. I just want to emphasize, right now it's an unsigned document in Liberty's hands. So we will provide either the complete executed agreement or the current draft at that time.
Okay.
That gets back to my other point. So Liberty is using this settlement agreement as a way to delay execution.
I understand.
That's what's going on here.
I get that, and all I can say is this. I'm not going to tell anyone what to do or not to do. But, Mr. Kemp, you're free. I tell this everywhere. Do what you think is in the best interest of your client. And That's all I can say. That actually came up in a real big discussion in another case, and I had to explain to the lawyer. I said, "Look, I can't tell you what to do. I'm not an advocate."
So the motion,
We have.
the motion will be denied, Your Honor.
What I'm going to do is this. No, I'm not going to do that. I'm going to reserve ultimately because I want to see what we have at the status check. But I've ruled. You understand this? I was real clear. The summary judgment finality and also the removal to federal court. I'm not accepting the dual jurisdictional argument. I'm going to reject that. Once it's out, once it's in federal court, I no longer have jurisdiction. I want to find out a little bit more on the where the settled claims are, if anything. And like I said, last but not least, notwithstanding all this, all lawyers should do what's in the best interest of their clients. That's all I can say.
Thank you, Your Honor.
And what is that status check?
Do you want a special session or no?
I don't know. I don't know what we have available. What do we have?
We can do a special session on Monday, February 26th.
How's that? Special session.
Did everyone hear that? Monday, February 26th at 10 a.m.
Is that good for everyone in the courtroom? Is that fine?
Yes, Your Honor.
Okay, that's what we'll do.
Along the lines of acting in the best interest of my client, can we at least have a confirmation that Mr. Kemp is not to execute on what he thinks is a final judgment pending this hearing on the 26th?
Well, Judge, I'll do this for him. We'll get the execution sale rolling, but we will put the date after 2/26, and that way there's no execute. In the execution, I mean, it's not. We're not going in and taking payroll. We're not going in and trying to sell a Milwaukee building or anything. All we're executing on is the bad faith rights. That's the only purpose of the execution.
I understand.
So you know, in a way, it really helps Milwaukee. But I will delay the bad faith. I will schedule the execution sale for after February 26th, and that way he doesn't have to worry about being able to come in here before then.
Yeah, and we'll discuss it.
Judge Sam Polsenberg, I think any
Well,
actions
Mr. Posenberg, before you get started, Mr. Posenberg, before you get started, I don't want to cut you off. I just want to say good morning to you, sir, and you have the floor. And you're a little
I
unclear.
think any,
Go ahead.
yeah, but I think any, none of them should be allowed to go forward.
And
Can
Mr.
I mind meld with Dan for a second?
Mr. Posenberg, you broke up.
Yeah, Judge, I mean, if they want to post
Story of my life, Judge.
they don't have anything to worry about here.
Yeah. Mr. Posenberg, state that for the record. I didn't hear you. Is he having difficulty?
I think so. I would imagine that he was going to say that any execution would be.
Judge, I think I'm being pretty gracious here, delaying the execution until after the hearing. You know, I mean, I can't even get it started.
Not while we have unresolved claims.
Judge, I'm sorry they have technical difficulties. We do have an attorney here, you know.
Go ahead.
Thank you, Your Honor. No, I think we're good with the assurance that this motion. It sounds like you're saying you're reserving ruling on this motion.
I need to know
Status
more.
check,
And
right?
I've made rulings as far as the summary judgment finality and removal finality. The only remaining issue is what's the impact of the settlement, if any. And secondly, I do have a concern in this regard. I mean, if there's a settlement in principle and it's being delayed because of some potential impact of this case from an appellate perspective, and also execution and the impact of Rule 54. I mean, that parties have rights to do what they want to do, but just as important too, I want to make sure that at the end of the day, whatever appellate rights are available for both parties are there.
I agree with that. Yeah, and just to clarify, there was the the settlement that Mr. Neal talked about with respect to the Liberty and the bankruptcy court.
And the UNFI claims, something like that.
Well, I won't try to second guess what Mr. Neal said, but I believe he stated that that would not resolve the pending claims
Yeah, and we'll find
in
out.
this action
Yeah,
or
yeah.
any of the claims against Gold Coast, which would.
If it resolves all the claims against Liberty, and Liberty is the only insurer, I'll just file a 54B certification, because that's just.
That's basically what.
That's just a claim that Liberty's waving around to delay the execution. So we might even do that and set it down for the 26th to cut through the knot here.
I understand, and that time's available. And what's today? Oh yeah, that's that's enough time. If that's filed, I'll make sure you have enough time to file an opposition to it, and we'll hear that on the merits too. And so, what I'm going to do is this: we'll hold everything. If you want to get the process started, but don't do anything, Mr. Kemp.
I will not do an execution.
We're
back here.
And everyone do what's in the best interest of your client. We'll find out where we're at on the, what date is that?
The 26th.
All right?
Thank you, Ron.
Everyone
Thank
enjoy.
you, Your Honor.
Thank you, Your Honor.